Members. I know Representative Herr has a full night with us, but also is doing double duty, having to sign into pensions, but I see she's with us now. So the first bill on the agenda today is this evening is House File 399. Representative Herr, would you like to move your bill to be placed on the General Register?
So moved, Madam Chair.
All right, your bill is now before us. And I forgot, you did ask me. Representative Herr did have a couple follow-up answers to some questions from earlier today. So I did want to give her a minute or two to share that information with the committee. If there's any additional information that members need, you can follow up with Representative Herr after we adjourn. But Representative Herr, why don't you go ahead and share that information with us?
Thank you, Chair Becker-Finn. And I think that I might have omitted to say this when I first presented the bill earlier today for House File 398, the standard heating bill of 68 degrees for a specific time period, that there is already local municipalities that already have this 68 degrees minimum requirement. And so what I did do is call a couple of the different cities who do enforce these ordinances, and to answer some of Representative Robbins' questions, which were really good questions around why the 36 inches or 36 feet, the requirements that we give out measurement is actually to protect the landlord so that somebody isn't taking a temperature right next to a window or an exterior wall saying that it doesn't meet the 68 degrees requirement. And so that is actually to help provide guidance and to ensure that temperature is being taken in a consistent place. And so hence that's why the requirement is given for the specific distance. The other question around if specific rooms, if different rooms have different temperatures, in that they did say that in this particular city that I spoke with, the person had 30 years in inspection and enforcement of the housing ordinances. And they said that in that time, they've never had an issue in which a landlord could not address a situation when the 68 degrees wasn't met in specific rooms. And so they work very closely with landlords in order to do that. And landlords actually have said that they agree that this is one of the most important things that can be done, because it is heating is the one reason in which somebody it can either stay in their unit or not stay in their unit. And so landlords generally believe that this is actually a really good requirement to have. And then they also, and I did ask on the undue burden that this might lead to a landlord, and they said, and this particular person who oversees the inspections and enforcement of this ordinance said that there's never been an issue in which a landlord could not address, that a landlord decided they were no longer going to rent, or that it was going to cause undue burden for them in order to meet the ability to do so. And this person had a 30-year history in doing this work. And I wanted to also just address the fact of that around the energy programs, that I did talk to Excel Energy, who said that this is not an issue because their program redirects energy at peak times, which is usually the summertime when people use their air conditioners, and that the winter programs actually has no impact of this heat requirement. They said that they would do some more research and get back to me, but they said that they did not foresee this being a problem at all with anybody who is enrolled in an energy program.
Great. Thank you very much, Representative Herr, for those very thorough follow-ups to the earlier questions and putting in that extra work during a busy week to get those answers quickly. So now House File 399 is in front of us. So please tell us about House File 399.
Thank you, Madam Chair. So House File 399 deals with just two issues. Fees, my apologies here, get myself on order. Fees for non-optional services and privacy. So an increasing number of landlords charge non-refundable fees for non-optional fees services rather than including the cost in the advertised rent. As you'll soon see, some leases include really bizarre fees like move-in fees, or even more sort of odd is that, one landlord charged a January fee and there was no explanation to why there is a January fee. Regarding privacy, the current statute uses the subjective term of reasonable notice for how much advance notice a landlord must provide before entering a tenant's home for non-emergency issues. As you'll hear from our testifiers, the subjectivity leads to some serious violations of renters' privacies. And so I have a few people here today, a few people here today to speak to the details of the bill and answer any questions that the committee might have. And the first person is Samuel Spade, who is an attorney at Homeline.
All right, Mr. Spade, please, I know you were with us this morning, but please introduce yourself for the record again, and then go ahead with your testimony.
Thank you, Madam Chair, members of the committee. My name is Samuel Spade, and I am a staff attorney at Homeline and Homeline's research director. The bill does cover both fees and privacy. I'm going to start with fees. One important piece of context for this bill was brought up this morning as well, which is that leases are almost always drafted by the landlord. Additionally, due to the lack of affordable housing and accessible housing for low and moderate income renter households, tenants are often put in a position where they simply must accept whatever the terms are in the lease. They don't have other choices or other options. Thankfully, Minnesota protects them from signing away or waiving many of their rights under law. For example, the rights to repairs, their security deposits, and many others. But there are some serious gaps, and fees are one that directly impact the affordability and stability of people's homes. We are seeing more and more landlords charging fees for non-optional services, things that are not included, rather than including these costs in rent. These are things like move-in and move-out fees, lease processing fees, and more. And it's really not about the tenant failing to read their lease. This was brought up in a prior committee. These fees are almost never advertised or brought to the attention of the tenant in a timely manner. For example, landlords will draw tenants in with what is essentially a deceptively low rent amount in advertisements, for example, and then these fees will be written into the lease so the tenant will see them, but the tenant will only see them after they've paid an application fee or a deposit to hold. Maybe they're not even given the lease until they are the day of, ready to move in. So they've been told what the rent is, but all of a sudden when they get their lease, they find out that their rent is effectively going to be significantly greater. And again, often at this time, they've invested a lot of money, time into the property. They may not have other options. And we've seen leases with a variety of these types of fees. For example, one where the tenant agreed to a non-refundable administrative fee. These fees range from $100 to $165 we've seen in leases. There was one with a global amenity fee of $15 per month, which is effectively just a rent increase of a $15 per month. And this complex was widely advertising all of their amenities as part of the deal. So again, the tenants were being drawn in with one thing and finding out only later. A lease has a new account fee, or monthly administrative billing fee, and we've seen leases with fees that I find particularly egregious, that they actually require the tenant to pay money in order to pay their rent, often in the form of some online surcharge. And I think, again, it is worth repeating that this is not about the tenants reading or not reading their leases. These fees are simply not disclosed in advance before the tenant has sunk time and money into the property, and again, may not have other options because they've already passed on their other choices. This bill remedies that by prohibiting non-refundable fees for non-optional services, and it would prevent tenants from facing these concealed charges until it is too late. The second issue is privacy. Privacy in one's home, understandably, is a very important need for everyone. It is among the top 10 reasons that people call us. We had over 700 privacy calls last year, and privacy violations can be a source of immense discomfort and feelings of insecurity in a person's home. Imagine suddenly having a stranger or even someone you know just walk into your home and start wandering around while you are there. Maybe you're helping your kids with your homework or their homework, cooking dinner, or, as is actually the case, showering. Landlords walking into the tenant showering is not some extreme or hypothetical situation. I take this exact call several times a year. I've taken two this year already, and in one case, it was the tenant's daughter who was home alone when the landlord came in unannounced without prior notice. This issue is only magnified right now, of course, during COVID-19, when many children are home doing school remotely, or people are calling and inquiring about their rights because they're immunocompromised or simply concerned for their health and safety. And Minnesota does currently have some privacy protections in place for tenants. However, these protections are vague and often don't offer a substantial remedy. For example, many people believe the law requires 24 hours notice before the landlord can come in. That is not currently the case. Existing law only requires reasonable notice. And this reasonable requirement is very subjective and is often interpreted by landlords to mean much less than 24 hours. A landlord can try to argue, for example, that 2 hours is reasonable or 4 hours is reasonable. Notices may also be given for blanket periods of time. For example, I'm going to come in anytime next week from the hours of 8 to 5 p.m. So effectively the tenant can't shower or do anything like that that they wouldn't want to be interrupted and are walked in on for the entire week. And again, the landlord can argue this is reasonable. And if the tenant wants to say that it's not, often their only recourse is to file a court case after the violation has actually occurred. And then even if they win, the penalty for the violation is only $100. This remedy is simply too small to be effective. And in most cases, tenants won't even file a court case for this amount. So violations often go unpunished, and there is little incentive for the landlord to change their ways. This bill would remedy that by requiring a minimum of 24 hours notice from the landlord. In non-emergency situations, it doesn't change the amount of notice the landlord has to give in emergency situations or the way the landlord has to act in emergency situations. And it would limit the landlord to entering between 8 a.m. and 8 p.m., requiring the landlord to specify a 4-hour window. And if these rights are violated, the tenant would have the ability to sue before or after the tenancy for a meaningful penalty. Thank you for your time. I'd be happy to answer any questions.
Thank you. We do have one other person signed up to testify. Michael Dahl, please introduce yourself for the record and go ahead with your testimony.
Yes, thank you, Chair Becker-Finn and members of the committee. My name is Michael Dahl, and I'm the Public Policy Director with Homeline. I had worked with a man named Drew Mayers on some testimony that he wanted to provide this evening, and so I'm just going to read his remarks for the committee record. My name is Drew Mayers, and I was asked to provide testimony about my recent experience with trying to rent a unit in the St. Paul area. My partner and I have spent the last month looking at and touring different units to find one that we thought would be a good fit for us. We finally found a good unit within our budget with a monthly rent of $1,095. We toured the unit and decided to go ahead with and put down our deposit. After we had already put down our deposit, we were presented with a lease for the unit, which was 46 pages long. As I sat down to read through the lease, I noticed the rent amount was correct, as well as a pet fee, which we had agreed to pay because we had a cat. However, also on the lease, we were told that we were never told about was a $9 per month administrative fee for access to an online portal to pay our own rent. On top of that, there was a carpet cleaning fee, which would fall under the category of move-out fee discussed before. The carpet cleaning fee, we were required to have our carpets in the unit professionally cleaned and then provide a receipt to the landlord as proof that we had done it. If the carpets weren't cleaned to the landlord's satisfaction, we could be charged with an additional carpet cleaning fee for the landlord to hire another service and clean the carpets again. I got the estimates from 3 carpet cleaning businesses, and they ranged from $250 to $400. Assuming the worst case scenario and the landlord wanted the carpets cleaned a second time, it would be in almost an entire month's of rent and fees we were not notified before placing down our security deposit. After learning about these fees, as well as possibly others that were hidden among the 46 pages, we decided not to move forward with the unit. If the fees would have been more transparent up front, or at the very least, if they were mentioned without including a dollar amount, we would most likely decided not to choose the unit and continue our search. For us personally, it was kind of a heartbreaking to finally find a unit that we liked and then find out afterwards the rent we were told upfront was not the actual cost it would be. Thank you for the opportunity to testify in support of House File 399.
Thank you. We don't have any folks from the public signed up to testify. Members, do we have any questions for Representative Herr or the testifiers? Representative Scott.
Thank you, Madam Chair. And I want to bring members' attention to, I think the Multi-Housing Association submitted some remarks. Their testifier could be here at this meeting, but I thought they brought up a really good point in that. So if there's a delivery of a dishwasher or something like that, and the delivery person has to, they usually give a window of opportunity, and if they have to move that, and the landlord has already arranged for this other prior 4-hour window, it doesn't leave much flexibility. They're going to have to probably have that dishwasher, whatever it is, delivered at a later date. And so, I mean, there's a certain convenience factor here that's important to remember. And the other issue I thought was really a good point was, so the landlord says, I'm going to be there between 10 and 2 and they show up at 10 till 10, and they could be in violation of this law and have this month and a half worth of rent fine to pay. So I think those are just a couple of good examples of where this doesn't allow much flexibility. And I understand, I mean, just as a practice, we always try to give our tenants 24 hours, and we call them and say, hey, you know, we need to do X, Y, Z. You know, we like to give people 24 hours, but would you be willing to do, you know, could we come, you know, 12 hours from now or 16 hours from now? And people, they say no, and we'll wait. But most of the time, people are amenable to that, and so it just takes kind of away the kind of a good working relationship that you have oftentimes with a tenant. And I certainly understand the point of, you know, your 17-year-old daughter's in the shower when the landlord shows up without notice. That's unacceptable. But I'm just not sure that this is the right balance of going forward. So just more comments really than a question, Madam Chair. Thank you.
All right. Thank you, Representative Scott. Any response, Representative Herr?
Yes, and I'll just respond quickly, and then I'll let Mr. Spade answer as well. But I think that, and I agree with Representative Scott. And what I would like to point out is that this bill language actually doesn't prevent a landlord and a tenant from agreeing that if a landlord needs to come because a dishwasher is here, for them to say no, especially if a tenant has been waiting for it to get delivered. I think that there is always, you know, communication between the two, and agreement to be made outside of that, that means that the landlord would not violate this if it's an agreement between the two parties. But I will let Mr. Spade expand on that.
Mr. Spade.
Thank you, Representative Herr, Madam Chair. What Representative Herr said, I think, is exactly correct in the first part of the answer, which is landlords can definitely work with tenants to come in. If they show up 10 minutes early, they can come in. If they say, hey, this is the only time the dishwasher can arrive, again, the tenant can certainly agree to allow the landlord to come in. What I think is important to remember, though, is that ultimately, again, it is the tenant's home and the tenant is paying for that home. And yes, in some cases, it might be a little bit harder for landlords to come in. They don't get to come in whenever they want. That's already the rule. Now they will have to wait at least 24 hours, which most landlords already do. But the person who should have to bear this burden is the landlord. Convenience, I heard the word convenience mentioned by Representative Scott. It would certainly be more convenient if landlords could walk into tenants' units whenever they wanted to. The point is that landlords shouldn't be allowed to do that. The tenant should have the convenience of having the privacy in their own home and the ability to control it. And again, as Representative Herr said, landlords and tenants could always agree to something else. This is just when can the landlord come in without any prior sort of acknowledgement or agreement from the tenant.
Thank you. And members, I'll also point out on line 1.22 that this is regarding a time of entry to the property. I could certainly imagine scenarios where, there's plenty of times where deliveries are made to my home when I'm not here, and there are ways to still do that even if you're not entering the property. Not seeing any other hands. Representative Herr, closing remarks? Oh.
Thank you, Chair Becker. Sorry about that. No, I have no additional remarks, just that I renew my motion that House Bill 399 be recommended to pass and place in the General Registry.
All right. Thank you, Representative Herr. The clerk will take the roll.
Chair Becker-Finn.
Aye.
Representative Moeller.
Aye.
Representative Scott.
No.
Representative Feist.
Aye.
Representative Frazier.
Aye.
Representative Grossell, excused. Representative Herr.
Aye.
Representative Hollins.
Aye.
Representative Johnson.
No.
Representative Liebling.
Aye.
Representative Long.
Aye.
Representative Mortensen.
No.
Representative Novotny.
Pass.
Representative Farr.
No.
Representative Robbins.
No, thank you.
Representative Fang.
Aye.
Representative Zhang.
Aye.
There are 10 ayes and 5 nays.
And Representative Novotny, did you want to vote or do you still want to pass?
Pass.
You got it. All right. The motion prevails and House File 399 is on its way to the General Register. Thank you, Representative Herr. We'll keep going with you. Next up is House File 400. Would you like to move your bill to be recommended to be sent to the General Register?
I would, but Madam Chair, I do have an author's amendment to this bill. I don't know if I have to move that first or should I move the whole bill first?
No, you got move the bill first.
Okay. So yes, Madam Chair, so moved.
Okay, now that we have the bill in front of us, I note that you do have an author's amendment. It is the A1 amendment. Would you like to move that amendment?
I would, Madam Chair, and the amendment just provides clarifying language to subdivision 5. This changes puts the bill in the desired form.
You got it. All right, any discussion to the A1 amendment? All those in favor, please say aye.
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 Opposed? All right, the A1 amendment is adopted. Representative Herr, please tell us about your bill as amended.
Thank you, Madam Chair. And this bill actually is the easiest of all my bills. This bill allows renter to break their lease with ample notice if a physician certified condition, illness, or disability makes living in their current housing a health issue. This bill has been in the works for a while. What is in the bill is compromise language between advocate groups and entities that opposed it initially when it was first drafted. I would like to know that this bill did pass out of the Housing, Finance, and Policy unanimously with bipartisan support. Again, I don't have a lot to say about this particular bill because it's pretty straightforward. It's giving clarifying definitions and clarifying language of the additional criteria for being able to break the lease for this medical condition or illness or disability issue. And so Samuel Spade is here to testify, and I will yield my time to him.
All right, Mr. Spade, please go ahead with your testimony.
Thank you, Madam Chair. Again, this is Samuel Spade with Homeline. Minnesota law currently has only a few reasons that a tenant could unilaterally terminate a lease midterm, so say 6 months into a one-year lease. The current reasons are if the tenant was a victim of certain forms of domestic violence, if they are called up or transferred to active military service, if all of the tenants on the lease die, or if the building becomes condemned or unlivable, and in some very rare instances by judge's order. There is currently no state law that would allow a tenant to end their lease specifically due to a medical issue. For example, a tenant may have a stroke that requires them to have much more significant medical care, or perhaps an existing medical illness becomes much worse, again, requiring greater care of some kind. However, if a tenant is in the middle of a one-year lease, they cannot legally terminate their contract and are going to face the choice of either having to stay where they don't have the required medical attention or break their contract and possibly suffer very severe financial consequences. We take these calls regularly, and they can be very difficult conversations to have. Our current advice to tenants is that they have to work with their landlords to come to some sort of negotiated agreement, or hope that their landlords can re-rent their place quickly if they decide to simply leave. Otherwise, the tenants are in a situation where they may have to choose between, again, staying in the home or having that financial consequence follow them around. I also want to point out there's no federal law that would explicitly allow a tenant to break their lease for these reasons. Landlords do have to provide reasonable accommodations, but reasonable accommodations seldom include full termination of the contract. At best, a reasonable accommodation request might require the landlord to try and re-rent the unit. However, in some cases it might not. And that ambiguity is the real issue. In every case, the landlord and tenant have to have a conversation about what is reasonable. The tenant cannot simply rely on it. And if they can't reach an agreement, again, the tenant can only resolve this by going to court, which will offer no guarantee. So the tenant is once again faced with that choice of, do they stay where they don't have enough care, or do they leave and pay and face a possibly fairly severe financial consequences? And I say fairly severe, but again, imagine that a tenant is paying $1,000 or $1,500 a month. If they leave, 2 months in or 6 months in, even 8 months in, and that could be several thousand to more than $10,000 worth of debt that in a worst case scenario could follow the tenant. This bill remedies that by giving tenants an official way out of their contract. As Representative Hurst said, it's a fairly conservative bill that has been negotiated and applies only in limited circumstances. It requires a tenant to move to a medical care facility defined in the bill after getting notice from, or after getting a note from a medical professional. The tenant is still required to give at least 2 months notice and of course pay rent during that time, along with supporting documentation in order to use this option to break their lease. And of course, during that 2 months, hopefully the landlord would be able to find a tenant. It is also worth noting that a growing number of states, currently 8, have enacted similar laws protecting vulnerable citizens who have medical issues as well. Each state is a little bit different, but in general, they require somewhere between 30 to 60 days notice and some type of severe illness or disability in order to break their lease in that circumstance. This bill, again, would help those that are among the most vulnerable in Minnesota's population, giving them a way out of their contract when medically necessary, and I would urge the committee to pass it.
Great, thank you. We have one other testifier signed up, Lisa Moe. Please introduce yourself for the record and then go ahead with your testimony.
Hi, Madam Chair and committee members. My name is Lisa Moe, and I'm President and CEO of Stewart Companies. We're a Minnesota-owned and operated company for over 51 years and manage properties in many parts of the metro area with heavy concentration in Plymouth, Hopkins, St. Paul, and surrounding communities. House filed 400, the infirmity bill is one that would create confusion with federal fair housing. In circumstances where ADA would create a reasonable accommodation, this proposal could have a differing timeline for compliance. What may be requested of the residents and could pose challenges for property managers due to the conflict with federal law. The proposal goes on to allow breaking a lease without any prior conversation with the property manager. If a 60-day notice is sent out due to not having an accessible unit, the resident includes their documentations for the need and acceptance to another location, but the current property manager is able to provide accommodation, it's not clear if the resident is obligated to stay. Some aspects of this bill look to add facilities to those potentially not covered by the Fair Housing Act. For example, the infirmity protection could be extended for the inpatient chemical treatment programs or housing for those deemed a health threat, something that may be a duration for significantly less than a lease term remaining, potentially a week, a month, with a 9-month remaining in their lease terms. For this reason, we asked the committee to consider how this proposal looks to define infirmity. The proposal uses locations to define the individuals who could be considered infirmed. This is an unfortunate decision as it focuses on the facility and not the individual needs. Most importantly, the proposal lacks any duration an individual expects to be infirmed to meet the break lease requirement. There are several areas of law that already exist that could help guide how to remedy this issue. Those under the ADA considered completely disabled are expected to be infirmed and need significant assistance for the rest of their life. Also, a special exemption also exists for military individuals already who can break their lease if their service is expected to be 90 days or longer. And I've had multiple military vets that have broken their lease for service. For these reasons, we raise our concerns to this proposal and we ask that you reconsider. Thank you, Madam Chair and members.
All right, we don't have any other testifiers signed up. Representative Scott.
Thank you, Madam Chair. And can an individual, can they be considered infirmed for a duration shorter than the 60-day notice period provided in the proposal? Sometimes people kind of have a temporary setback in their health. And so I don't know if Representative Herr or the testifier want to address that issue.
Representative Herr.
Madam Chair, and thank you, Representative Scott, for the question. I am going to defer to Mr. Spade to respond to the question.
All right, Mr. Spade.
Thank you, Madam Chair. The statute does, I first want to go back to the part about disability. The statute does require that the tenant have a disability, and the tenant is also required to give 60 days notice, which means that if the tenant had something that would take less than 60 days, I'm not sure if there would be a benefit for the tenant to even give that type of notice, as they wouldn't need to move. They also have to have a doctor's note saying that that move is necessary for them. To answer the question most directly, though, I don't know all of these circumstances. There's a long list, and I have not reviewed every one of them for the medical care facility requirements. So I guess I have to say I don't know completely, but in general, there will still be the 60-day notice requirement, during which time the tenant has to pay. The tenant has to have the disability that would be a major mental impairment or material limit one or more major life activities, and they have to get that note from the doctor saying they need the care where they're moving to.
Right. Follow-up, Representative Scott.
Thank you, Madam Chair, and thanks for that answer. And I think that's, I know you said you didn't know for sure, and I think that's an important question to have answered. And so, you know, if the bill needs to be tweaked a little bit to allow for that. But, you know, my first inclination is to support the bill because, you know, we all have, you know, life happens to people. And with our aging population as well, there are going to be people that are going to be falling and breaking hips, and there are people that are going to be having strokes and those sorts of things. And so I think, again, most landlords are going to work with people, but I would think that 2 months would be an adequate amount of time to re-rent the unit or the home. And so I will support the bill, but I think those other questions of that concern needs to be answered. Thank you, Madam Chair.
All right. Thank you, Representative Scott. Any other questions from members? All right. Seeing none, Representative Herr, any closing words?
No, just that I ask for support of this bill. It is really, it's a good bill and it's very narrow in scope, and that I would just appreciate a yes vote for it.
All right. Representative Herr renews her motion that House File 400 as amended be recommended to be placed on the general register. The clerk will take the roll.
Chair Becker-Finn.
Aye.
Representative Moeller.
Aye.
Representative Scott.
Aye.
Representative Feiss.
Aye.
Representative Frazier.
Aye.
Representative Grossell, excused. Representative Herr.
Aye.
Representative Hollins.
Aye.
Representative Johnson.
Aye.
Representative Liebling.
Aye.
Representative Long.
Aye.
Representative Mortensen.
Aye.
Representative Novotny.
Aye.
Representative Farr.
Aye.
Representative Robbins.
Aye.
Representative Vang.
Aye.
Representative Zhang.
Aye.
There's 16 ayes and no nays.
All right. The motion prevails and House File 400 as amended is recommended to be placed on the general register. Our final bill for this evening is House File 835. I'm going to knock on wood, but if we play this right, there may still be daylight by the time we wrap tonight. So Representative Herr, we're going to keep on track here. Would you like to move your bill be recommended to be placed on the general register?
So moved, Madam Chair.
And I understand you also have an amendment to this bill. It is the A1 amendment. Would you like to move the A1 amendment?
So moved, Madam Chair.
All right. Any discussion to the A1 amendment? All right. All those in favor, please say aye.
Aye.
Aye. Aye.
Opposed? All right. The motion prevails and the amendment is adopted. Representative Herr, please tell us about your bill as amended.
Thank you, Chair Becker-Finn and committee. This is our last one, so I'm going to hope we get us out of here when there is sunlight, right? Cross our fingers. And thank you for hearing House File 835. This bill is a housing policy proposal related to tenants' rights. The bill has 4 parts to it. The first is banning housing discrimination based on public assistance, which is Section 1 through 3. The second is eviction expungement expanded, which is Sections 4 and 5. The third is pre-eviction notice required, that's Section 7. And the last is that an eviction filing is not public until a judgment is rendered, which is Section 7. If needed, I can provide a brief overview of each of these sections. I do want to be thoughtful of the time in front of us, Madam Chair and committee, so please let me know if you would like for me to go into more detail in each section. Otherwise, I can just turn it over to our first testifier to talk through some of the elements of the bill.
Great. Thank you, Representative Herr. I'm going to give everyone the benefit of the doubt that they have read the bill and have an opportunity to think about any questions they may have. And I do want to make sure we have time for the testifiers. So we'll move to the testifiers first. First on the list is Larry McDonough. Please introduce yourself for the record and then go ahead with your testimony.
Thank you, Madam Chair. My name is Larry McDonough. I'm Senior Minnesota Counsel with the Lawyers Committee for Civil Rights Under Law. And I'm here to discuss, starting with, let me just get my notes in front of me, starting with Section 4. I've been an attorney for almost 40 years. I've represented both landlords and tenants with about 10,000 that I've assisted over the years. And I've been involved with lobbying on landlord-tenant laws since the mid-'80s. And I've also been a landlord off and on since the mid-'80s until I sold my last property about 6 years ago. So starting with Section 4, this deals with the issue of eviction expungement. And I do have to apologize that I don't have the author's amendment in front of me. So if I'm misspeaking at all, Representative Herb, please jump in and correct me. Sections 4 and 5 deal with expungement. And right now, the law of expungement limits two different categories, mandatory expungement and discretionary. Mandatory is very limited to certain mortgage foreclosure and contract for deed cases where an occupant moved before an eviction was filed or the tenant didn't receive the right type of notice. So that's the limit on mandatory expungements. Discretionary ones are based on a 3-part test about what type of merit the landlord's case had and what's the interest of justice and the interest of the public. And the problem with the current statute is that many thousands of evictions stay on records for many years, and it costs a tenant $300 to file for a motion for expungement. And years afterwards, it's hard to prove the basis of the case because that's one of the required factors for discretionary expungement. And many landlords will flag eviction cases regardless of the outcome, and the tenant never gets past that to show their own viability. And this creates homelessness and shelter populations and affects children that are unable to be consistently housed. And I'll just want to give you a very brief case example. I represented a couple of young women in a law school clinic about 20 years ago, maybe a little bit less. And they were friends of a couple of kids that were killed in a school shooting in Cold Spring. These were high school students, and the clients of mine were young college students. They were both going back and forth for the funeral and other things and meeting up with friends and stuff. Each thought the other had paid the rent. They hadn't. The landlord filed an eviction case, and they came back and found out about it. They settled up with the landlord, and everything was good. They stayed. They later moved, only to find that this eviction was on their record, and it was following them around. And they did a request for an expungement, and a referee looked at the statute and said, well, I can't see that the landlord did anything wrong with the case, so your request is denied. What the bill would do is change both discretionary and mandatory expungement. Section 4 changes the discretionary analysis to whether the eviction case is a reasonable predictor of future tenant behavior, and that's kind of the big change there, and then also looks at the public interest and the tenant's interest. So that Cold Spring case, I think, would have been expunged under this change because there wasn't anything in their history that indicated that they were going to be bad tenants or not pay the rent into the future. This was really an isolated circumstance. Section 5 adds to mandatory expungement a number of case outcomes where expungement would be mandatory, like the tenant wins or the landlord loses. Or the parties reach an agreement for expungement, they reach a settlement and there's some conditions and the tenant fulfills those conditions, or if the case is older than 3 years. And so the effect of that would really allow more tenants to get past the flag of an eviction record following them around to show their viability, and would lead to less homelessness and shelter costs. I can say from my experience as a landlord, this change would not force any landlord to rent to anyone. Landlords can still screen for references. That's what I did until I sold my last property. So I think it'll provide some equity here, but still protect landlords. The next part of the bill is sections 6 and 7, and these deal with and I should note that both what I've discussed earlier and what I'm about to discuss now are nearly identical to House Files 20 and 265, but they've been merged into this bill. So right now, a landlord can give a permissive 14-day notice to a tenant if the tenant has not paid the rent, but they don't have to do that. And what this bill does is, sections do, is essentially take that from a permissive to a mandatory. So the permissive quality of that notice is in section 6, and that's removed. And what section 7 does is replace it with a mandatory one. And this is similar to, so this notice is very similar to the notice requirement that a tenant has if he or she wants to file a case against a landlord to say the property needs to be fixed up. That's called a rent escrow action or a tenant remedies action. It's also very similar to the types of notices that we see in public housing. Housing landlords have to give a notice for non-payment of rent. So the notice would have to state the amount of rent, and it would have to state some information as to who's authorized to collect the rent and some information about financial and legal assistance. It also makes some changes to the emergency assistance process. We've seen over the years, sometimes emergency assistance doesn't get issued in time because agencies have trouble kind of verifying that there's an emergency or that there is what the debt is. This type of notice would qualify for a determination of an emergency and for verification. So hopefully would streamline the process of emergency assistance and get the money to the tenant, and then the eviction case never gets filed. The last thing that section 7 does is it adds that an eviction action remains a private record until there is a final judgment. And this is similar to what's done in a number of other states around the country, so that simply the allegation that the tenant has done something wrong doesn't start to really follow that person around until the courts actually determined that those allegations are correct. With that, I will end my testimony, but I'll be available for questions. Thank you.
All right, thank you. We will move to the next testifier I have signed up is Linda Soderstrom. If you could introduce yourself for the record and then go ahead with your testimony.
Good evening, Chair Becker-Finn and committee members. My name is Linda Soderstrom, and I live in Southeast Minnesota and do rely upon a Section 8 voucher. In 2017, totally unexpected, I was served eviction papers, and that eviction action is still on my record today. This was very scary and stressful at my age. I came home to find papers posted on my door, which stated my deposit, interest, and penalties totaling $1,200 were due the next day, though I had been living there a year. Hennepin County had never disbursed my voucher deposit, and this entire misunderstanding was an easily resolved clerical error. I immediately saw to that and then contacted an attorney who phoned the owner's lawyer, and as I sat there in the office, this case was dropped and no eviction occurred. I never lost my home, but that eviction action stays on my record today. I would need $300 to file for expungement as well. If House File 835 had given me 14 days pre-eviction notice at that time, this very arduous experience could have been spared me. It has been 4 years now, and this eviction on my record would have elapsed already if we had the 3-year limit. This would not come up whenever I tried to rent. In my case, neither the eviction or the expungement would have been needed with a 14-day period to get to the bottom of whatever the problem was. And this wrong eviction action would be removed by now. Thank you for having me to share my experience. And if you did have any questions, I'd be happy to answer. Thank you.
Thank you very much for your testimony. We do have 2 other testifiers signed up. Bernadette Hornig, please introduce yourself for the record and then proceed with your testimony. You may have to unmute yourself.
Sorry. Okay, can you hear me now?
Okay.
Yep. Please introduce yourself for the record and then go ahead with your testimony.
Madam Chair, members of the committee, my name is Bernadette Hornig. I'm here today as board chair of the Minnesota Multi-Housing Association. I'm here to testify on the unintended consequences of House File 20 and the 14-day notice proposal. Evictions in Minnesota are expensive. We take eviction actions seriously as they have several effects that are bad for business. They cost significant amounts of money and may create an adversarial relationship with the resident. Additionally, costs associated with an eviction filing are rarely recovered when a tenant is evicted for non-payment and must be written down as bad debt. For these reasons, operators are reluctant to file an eviction. As operators, we seek alternative resolutions to eviction filings, including helping residents find emergency rental assistance, creating a payment plan, or settling with tenants to vacate. Under the proposal, some operators may seek to file notices earlier than they would have in the past. A 14-day notice effectively creates a 14-day opportunity to pay rent late without significant penalty. From this, we would see notices as early as the second, third, or the fourth day of the month. The reason this would become standard operation is to protect a property owner's right to file an eviction action in a timely manner. As the date of the court case is pushed further out, additional months of unpaid rent and court costs will continue to accrue to the amount of bad debt. Operators would have to consider adding this early business process at the start of every month to ensure some reasonable opportunity to recover their property and reduce their sunk costs. As a point of kind of just information for our company, we typically don't file until the second month that someone's behind. And that, again, that allows for the time for us to communicate with the resident and make sure that there's a plan in place. If there isn't or the resident's non-responsive, that's when we would file in the second month. Under this proposal, it would be more likely that we would have to include that language earlier, which, as Ms. Soderstrom indicated, is very stressful for the resident and can really throw them for a loop. So we don't want to threaten eviction to anybody when we don't actually intend or want to file on them. Currently, in many situations, operators wait until that grace period expires, typically on the 6th, and then they would provide just a late notice to a resident without mentioning eviction. We feel that this change will harden the relationship between residents and operators. This notice, I believe, will create an uptick in eviction filings. Currently, Minnesota is ranked 3rd or 4th best in the country per capita in eviction filings, according to the work of Matthew Desmond and the Eviction Lab. For fair housing reasons, if a notice letter states that an eviction will be filed in 14 days, then the eviction must be filed once that time is reached. With that in mind, this legislation could actually increase the number of eviction filings in Minnesota. I urge you to carefully consider the unintended consequences of this bill so that we do not harm the resident-landlord relationship and that we do not prematurely initiate evictions, which I believe will result in more evictions rather than fewer. Thank you for your consideration. I'd be glad to answer any questions.
Thank you for your testimony. And last, I have Cecil Smith. If you could please introduce yourself for the record and go ahead with your testimony.
Thank you, Chair Becker-Finn. Madam Chair, members of the committee, my name is Cecil Smith. I am President and CEO of the Minnesota Multi-Housing Association, which represents nearly 1,800 members and 400,000 units of housing in our state. I come before the committee to respectfully raise our opposition to the major expansions in House File 835. We believe it will lead to more challenges in the rental housing market than it intends to solve. Section 1, Subdivision 1, and I'm going to go through a number of the sections here. Section 1, Subdivision 1 is an expansion of protected classes in housing, but in this case, it carries attached costs. In other words, an unfunded mandate. Government housing assistance programs have significant costs and due diligence requirements and were designed as voluntary programs. This proposal would create an obligation on all owners and managers to sign contracts with government entities and to engage in these programs, follow extensive rules, no matter the extent of the program burdens, and further train staff on these program obligations. This also would further allow all levels of government to create mandatory assistance programs. This is concerning because the proposal does not take into account what these how and what these programs operate on. For example, in Oregon, there's a COVID rental assistance program currently that's an optional program for landlords to participate in. The program provides that landlords must forgive 20% of the rent to accept 80% payment from the state. If a similar policy were implemented in Minnesota, it could mean managers are forced to forgive rents. Otherwise, they would face charges of discrimination. Let's turn to Section 5, Subdivision 3. As Bernadette just mentioned, Matthew Desmond's Eviction Lab has Minnesota as the fourth lowest eviction state in the United States. Among large cities, Minneapolis's rate of evictions is ranked as 201st, St. Paul is 217th, and Rochester is 225th. While concentrated areas of concern remain, Minnesota's eviction rate fell faster and farther than the country over the past decade. While every eviction is a crisis for the renters and the manager, we do not have an eviction crisis. We did not have one, and we will not have one. Energy and effort this moment should be on the eviction and lease termination moratorium off-ramp. This bill would also allow most records to be expunged immediately after the court reaches a conclusion or settles a case. After 3 years, 100% of eviction records would be expunged regardless of the circumstance which gave rise to the eviction action. Eviction records are one of many factors considered by most managers during the application screening process. Failing to properly screen applicants sets them up for failure, hurts other renters, and could be a financial and legal liability for owners and operators. Our members are additionally concerned when we examine the language in Section 4, Subdivision 2. Under the proposal, the courts can determine that an eviction, quote, is no longer a reasonable predictor of future tenant behavior, end quote. The courts are not operators of rental units. Judges are not housing management professionals and are certainly not currently equipped to understand what creates a reasonable predictor of future tenant behavior. When looking at criminal record expungements, there are procedures in place that must be followed to meet the standard of no longer a reasonable predictor. But this statute provides no such guidance. Allowing expungement by agreement of parties to the action without considering whether concealment is in the public interest is an extraordinary step that allows, even potentially for financial compensation, two interested parties to control the fate of a public record to the detriment of others. This is a concern as we have data which shows Minnesota's eviction rates ranks among the very best in the country. This elimination of this data set could create less public scrutiny of the actions of residents and landlords alike. I appreciate that Minnesota has reduced evictions further than most states, but this concealment of records will no longer provide these valuable insights into eviction data. This bill would also allow most records to be expunged immediately after the court reaches a conclusion or the case is settled. After 3 years, in Section 7, this bill would seal a public record, an eviction action filing automatically and immediately. That would raise the screening limits for all other residents, since a manager would have to assume that someone relocating had an eviction filing in a pending case. This is a terrible unintended consequence of the bill for all renters. For these reasons, we oppose this proposal, and I appreciate the opportunity to raise our concerns on House File 835.
All right. Thank you, everyone, for your testimony. We'll move on to member questions. It looks like the sunset is going to beat us, but that's okay. Representative Hollins.
Sorry, I had to find my unmute button. Thank you so much, Madam Chair. My question is to the author. Can you tell me a little bit about how this bill would impact communities of color?
Representative Herr.
Sure. Thank you, Chair Becker-Finn and Representative Hollins for the question. We do know that communities of color, people, BIPOC individuals are disproportionately impacted when it comes to evictions, when it comes to having certain items on their record, and that this would actually be something that would be helpful for them as they look for housing, to not have something that they did not truly earn end up on their record. And Representative Howland, I did just want to address what the prior testifier said, because I think it relates to your question about this immediate expungement. Of course, that is exactly what we're asking for, is because what it's being asked is not unreasonable. That if we do look at lines 4.12 to lines 4.18, it specifically identifies when somebody's record should get expunged. And I don't think it is unreasonable that if the defendant prevailed based on the merits, or that the court dismissed the plaintiff's complaint for any reason, or if the parties to the action have agreed to the expungement, if the court finds an eviction was ordered in the last 3 years prior to the date of the expungement was filed, upon motion of the defendant, the case is settled and the defendant fulfills the terms of the settlement. But these are not unreasonable things being asked. We're not asking to expunge somebody's record for any just reason and with nothing to back that up. And so I'd say that this is really important, especially because communities of color are already discriminated against when looking for just housing in general. Then when we add these other barriers in front of them around using vouchers or being able to not have a record that will impact their ability to rent future units, that not follow them as well. So I appreciate the question, Representative Howlands.
Thank you. Next on the list is Representative Scott.
Thank you, Madam Chair. And just a concern that I have, and the folks from the Multi-Housing Association did a good job articulating some of this, but the extension of the 14 days, the requirement to have that 14-day period is going to have some really, I think, negative unintended consequences. Our releases say that rent is due by the 5th. If you haven't paid by the 10th, then an eviction action may proceed. And of course, during that time, we try to work with people. We don't want people out. We want them to stay because for the stated reasons. It's expensive to file an unlawful detainer. The whole process is not, it's time consuming, it's expensive, it's putting, someone's going to be out of their housing potentially. So, but I want us to think a little bit about the fact that if you get this 14 days pushed out into the future, and a landlord then foreseeably could miss out on another month's rent, what that's going to do to the price of housing going forward. And believe it or not, landlords do these profit and loss. They look at their numbers and they have to figure in a vacancy rate. They have to figure in their expenses, what they've spent on unlawful detainers, on court proceedings, those sorts of things. And for market rent, you adjust accordingly with those expenses. So my concern is in the long run, you're going to be increasing the cost of housing, not lowering it, and possibly hurting the very people that we're trying to help here. So I just wanted to put that on the record that there would be some unintended consequences to pushing out this 14-day notice even further in the eviction process. Thank you, Madam Chair.
Right. Thank you, Representative Scott. Next on the list is Representative Moeller.
Thanks, Madam Chair. And I really appreciated the testifiers, especially Ms. Soderstrom. And I was curious if this bill, if it's enacted, would be able to apply retroactively for people in situations like hers.
Representative Hurd, you know the answer to that?
Madam Chair and Representative Moeller, I am going to defer. We do have Ms. Robertson, Lael Robertson here, and I will defer to her to answer the question on if this is retroactive, or Mr. McDonough, either one of the two, if they're able to answer.
Yeah, we'll go to Ms. Robertson if you want to introduce yourself for the record and go ahead with your testimony.
Sure. Good evening, Madam Chair, members of the committee. My name is Lael Robertson, and I'm the policy attorney at Minnesota Housing. Madam Chair, would you like me to address the question? Just address the question?
Yes, okay. Yeah, just stick to the question. Thank you.
Yes, okay. The bill does not allow for retroactive application.
All right, Representative Moeller, I think that answers your question. Any follow-up, Representative Moeller?
No, thanks, Madam Chair. I do see that Mr. McDonough had his hand up, so.
Oh, okay. Mr. McDonough, it seems like it's a yes or no question, but any response?
Well, I think that thank you, Madam Chair. I think the question might have implied two different concepts. The statute, the bill itself would not be retroactive, but the expansion of expungement would allow Ms. Soderberg to now use the new type of discretionary expungement to have her case expunged, and I think she probably would get it.
All right, thank you very much. Good question, Vice Chair Moeller. Representative Long.
Thank you, Madam Chair. Thank you, Representative Herr, for bringing another terrific bill forward today. You're on a roll. I am strongly supportive of this bill, and in particular of the protections for source of income. And when I worked in the federal government, it was extremely hard even for somebody to get a federal voucher to be able to support them. And oftentimes they would have real difficulty finding anybody who would accept that voucher, even if they got one. So this makes a lot of sense to me. Some of the testimony we heard was that this would increase costs. And I was curious, I have two questions on that regard. One is that would this bill require any landlords to accept less than market rate for rent?
Representative Herr.
Thank you, Chair Becker-Finn, and thank you, Representative Long, for the question. No, it would not. So the way the program works is that whatever the tenant can pay, they pay. So even if it's $50, then if the market rate for that apartment is $1,000 or that unit, then the program comes in and fills in the difference. So they always get paid market rate for the building, for their unit.
Right, follow-up, Representative Long.
Thank you, Madam Chair. And there was some discussion of the costs for a landlord to adhere to the program. My understanding from my experience is these costs are pretty minimal for the administrative requirements. And I was wondering if you could speak to those, Representative Herr.
Representative Herr.
Thank you, Chair Becker-Finn, and thank you, Representative Long, for that question. You are absolutely correct that there's actually only two operational requirements in order to be a part of this program. And so in order to be part of the SOI program. And so you are correct that it is not a cumbersome process for a landlord to enroll in it. They just have to do a few small additional items. And I do have that in my notes here, but I can't find it. So I don't want to make everybody wait for it, Chair Becker-Finn, but I can send that out of what the two steps are if people are interested in knowing what that would be.
That would be great, Representative Herr. If you could send that to Ms. Ganani as well, we can make sure everybody gets that information. Are any more follow-up, Representative Long? Are you good?
No, thank you, Madam Chair.
All right, thank you. Representative Frazier.
Thank you, Madam Chair. I echo what Representative Long said about Representative Chair her bringing this bill. You know, when I grew up, when I was growing up, my family used vouchers like this for housing to maintain stability, and in some cases. So thank you for bringing this. I think it's important. And the question I have is, you know, I always tell folks the issues that we're facing hit all four corners of this state. So my question is, how will this impact folks outside of the metro area?
Representative Herr.
Chair Becker-Finn, Representative Frazier, that is a really great question. I know that I saw Ms. Robertson's hand up earlier. I don't know if she could maybe address your question on this and maybe on the point that she wanted to make a little bit earlier, if that's okay, Chair Becker-Finn.
Yeah, that would be fine. Ms. Robertson, please go ahead.
Thank you, Madam Chair. Representative Frazier, I spoke before Representative Frazier. I was going to address Representative Long's question, where I believe he asked about market rate. I just wanted to make sure that it was clear that a landlord does not need to reduce their rent at all in order to make it reach the affordable level for a voucher holder. If their rent is already above what voucher holders are able to spend on their rent, then the landlord can say, you know, I can't rent to you because you can't afford my apartment. So there's no need for a landlord to reduce their rent in order to accommodate a voucher. Representative Frazier, we have heard that this actually has great effect in Greater Minnesota in a couple of different ways. Our HRA friend administrators from Duluth have talked about how their success rate, their placement rate of vouchers is in the 30% numbers, even though they have made a number of incentives for landlords to participate in the program, they still have difficulty in getting vouchers placed. I think the second thing that we see is in Greater Minnesota, where there are only a handful of actual buildings where they're renting apartments, or a handful of affordable apartments in a particular town, and those landlords don't accept vouchers. That shuts out actual entire swaths of affordability for people in Greater Minnesota.
All right, thank you very much. Any follow-up, Representative Frazier?
Just no, I think that emphasizes why we need a bill like this, and I will be supporting.
Thank you. Representative Vang.
Thank you, Madam Chair. Once again, I'm very supportive of this bill. It's really important, and it's about time that we have something like this to address a lot of the housing laws that has not happened yet, and that will continue to improve for many of our residents here in Minnesota. My question is relating more on the federal government's role on this. How will this interact with any of the potential funding from the federal government?
I'm guessing Ms. Robertson may be able to answer that question for us.
I'll take a gander at it, Chair Finn, Becca Finn, and Representative Vang. It shouldn't affect any of the federal dollars that are coming in for rental assistance, if that's what you're speaking of. Typically, I believe that Minnesota Housing is establishing, well, I know that Minnesota Housing is establishing the program with the federal dollars, and it's my understanding that those federal dollars won't be duplicated with people who have a voucher. However, if people who have vouchers are behind on their portion of the rent, they may be eligible for federal assistance if necessary, but there will be no duplication. The Treasury Department has been very clear about us needing to make sure that there's no duplication of those federal dollars with other subsidies.
All right, any follow-up, Representative Vang?
Nope, that is all.
All right, Representative Scott, and then we'll get to the vote.
Madam Chair, I'm just going to save my comments for the floor. There are just too many to make here at the moment. Thank you.
Fair enough. Representative Herr, any closing words?
Thank you, Chair Becker Finn. And I just wanted to say real quick that, Representative Scott, I do respect you enormously. You and I have been in this committee for a while, so I would love the opportunity that if you had questions specifically to this that you would like to work on or for me to vet further, I know you know that my word is good when I say I will try my best to accommodate those who want to provide feedback. And so I would love the opportunity to do that. I did just want to say really quick that to one of the testifiers' question about forcing landlords to work with, with the government and being a part of these government programs, that nothing in this bill says to a landlord that they have to do something specific. All it's asking is for them not to discriminate against somebody with a voucher. So if they have 15 people, applying for an apartment, it does not say that they have to take the individual with a voucher. It means they do all of their screening. And if there is somebody who is, a tenant that, is better for the apartment, we're just asking, don't eliminate somebody just because they are holding a voucher. So I just want to be really clear with that. And then the other point is that the provision around pre-eviction notice required that that landlords now, with that 14-day, the landlords are being asked to abide by the same standard that Minnesota already requires tenants to, who must wait 14 days for a landlord to fail to respond to a written repair notice before they are allowed to file a lawsuit. And so my feeling is that if it's good for a landlord, it's to get that kind of notice, it's good for a tenant to get the same type of notice. And so I just want to say that with that, I do appreciate the support for this bill, and I renew my motion for the bill to be put on the general registry.
All right, Representative Herr renews her motion that House File 835 as amended be recommended to be referred to the general register. The clerk will take the roll.
Chair Becker Finn.
Aye.
Representative Moeller.
Aye.
Representative Scott.
No.
Representative Feist.
Aye.
Representative Frazier.
Aye.
Representative Grossell, excused. Representative Herr.
Aye.
Representative Hollins,
Aye.
Representative Johnson,
No.
Representative Liebling,
Aye.
Representative Long,
Aye.
Representative Mortensen,
No.
Representative Novotny,
No.
Representative Farr,
No.
Representative Robbins,
No.
Representative Vang,
Aye.
and Representative Zhang.
Aye.
There are 10 ayes and 6 nays.
All right, with 10 ayes and 6 nays, the motion prevails and House File 835 as amended is on its way to the General Register. Thank you, members. It's been a very busy day. We have 2 more meetings this week. The agendas are posted and there is still a little bit of daylight. So with that, we are adjourned.